So, good evening. Welcome back to this session on corporate economic laws for CA final exams. And in the last class, where I had covered two topics, that is winding up, and thereafter I had covered miscellaneous provision. And today I will be covering another important topic, SEBI, where we expect at least one question coming out in the exam. Definitely, there's no doubt about it. One question from this particular paper of SEBI Act 1992. So quite important, and I think we'll continue with the concept that if you cover all these small topics where there is a surety that this the question will come from this topic, where we have certain kind of certainty, and also questions may be direct and something indirect, but we don't expect a lot of technicality in these type of topics. So I would suggest again to get ranks and good marks. You should definitely cover these topics, and we all understand the importance of each mark in our exams. So let us start with this topic of SEBI, just to see who all have logged in. Mancha, yes, good evening, Mancha. Mancha is here, and hope other people must have joined in. Viraj, yeah, good evening. Good evening, Viraj. So great to have you here. In the last class, I think people missed out because of whatever reasons. Let us now continue. Okay, so SEBI 1992, again, a game-changing year, as we all understand, because this was a year when stock market went through a lot of ups and downs and a lot of complications, a lot of scams in this year of 1992. And after the scam, which we all know it by the name of Harshad Mehta scam, thereafter this institution, this regulatory agency came into picture, and therefore it is in your course. And luckily or unluckily, people commit scam, and then the regulatory agencies come into picture. But yes, I think a great initiative by the government to bring in SEBI, which has regulated the stock market in a very efficient manner so far, taking control of the affairs of the stock market and the people involved in the stock market, and has been quite vigilant, proactive, and a lot of steps development has taken place since this agency had come into action. And that is why we see a robust stock market, which is again one of the best stock markets in the world. It's not about India. National Stock Exchange, Bombay Stock Exchange has been recognized one of the most developed stock market in terms of trading. And I'm sure with times to come, it is going to be the world's largest also in terms of trading volume. Though it may take certain time, but I'm sure that day would not be far away. So SEBI, when we talk of SEBI, I think again, for every act, we need to understand the holistic picture that if I talk of SEBI, what should come into your mind? Who are the people who will be affected by this agency, or for whom this agency is going to work upon? So 3I, I would say it is 3I, and 3I is issuers of security in the capital market, the companies, primarily the companies, intermediaries who are totally involved in this process of facilitating the stock market, raising of funds, primary market, secondary market, and the number of intermediaries are large in number. It's not only about one or two. There are many players who play an active role, and that is why we see a lot of opportunities in terms of profession, in terms of job, and yes, in terms of business. All three kinds of opportunities exist being an intermediary. And then finally, the investor. That means SEBI at large is responsible to the investors, which are in crores. That is why the importance of SEBI has grown over a period of time, and a lot of people have faith in this institution, and they believe that whatever is being done, that is being done to protect the investors. That has been one of the prime objectives of SEBI. So you can understand the importance, the scope, the extent to which SEBI makes an impact. If we talk about intermediaries, there are many, as I said, and these can be segregated further into two parts: the front end intermediaries and the back end. The front end is like the National Stock Exchange, what we see; the brokers, what we see; the back end are depository, registrar, and transfer agents, and the underwriters. There are so many other people involved in this whole process. So what we see is obviously again bigger. But then what we don't see is still much bigger. So CSDL, NSDL, so many agencies are involved in this whole process. So we have two kinds of intermediaries, the front end and the back end. I hope this will create a picture in your mind that how SEBI is going to function and to whom SEBI is going to make a difference. So our agenda is very clear, friends. We need to cover this whole act with some basic understanding of the structure, the powers of SEBI, and thereafter we have the penal provisions, which are very important, then appellate powers, recovery, and so on. So a lot of other things will come into picture. So it's a total act. It will serve you everything. So we have to start with the constitution and then thereafter the powers of everyone. The preamble, I think the preamble is very clear. The whole purpose is to protect the interest of investors, to regulate the intermediaries, to develop the security market and any other matter which is incidental to this whole process. And they have been doing this job very efficiently. So whatever we'll study will be in context with these three terms: PRD, DRP, protect, regulate, develop, protect, regulate, develop, protect, regulate, develop. So whenever we understand then or any action or any section which has been framed, it is either to protect, to regulate, or develop. So with this preamble in background, it was established as a body corporate with an office at Mumbai, and they have given the right to acquire, hold, and dispose of the property, and they can be sued or be sued in the name of SEBI, and with 4 regional offices, along with a lot of other offices at various locations also. So there will be office at, it may be at Delhi, or it may be office at Lucknow, there may be office at Surat, Baroda, Bangalore, and so on. But they have certain job to do. So they have regional offices. Along with the regional offices, there are multiple city offices at various locations also. So let's start with this SEBI, and the main function of the SEBI will be executed through a board. The board of SEBI, which is very powerful and recognized and respected in the world of financial market, in the government also. So there will be a chairman nominated by the Union Government of India. Then 2 members from the Union Ministry, and 1 member from RBI. So you will understand that it is a composition of majorly from Ministry, RBI, and 5 other members nominated by Union Government of India. Out of them, at least 3 shall be whole-time members. 3 shall be whole-time members. That gives again the strength to the SEBI that there are people who will be working whole-time for this SEBI exclusively. SEBI exclusively. So currently the chairman is a lady, Madhavi Puri. She is the current chairman of SEBI. Who is eligible to be appointed as the SEBI chairman? So person eligible to be nominated by central government, person of ability, integrity. This point is important. dealing in securities markets, special knowledge and experience of law, finance, accounting, and economics and administration. So that person who has got this much of experience, I think that person is eligible for becoming the chairman or the board member. So this is the crux, you cannot make any person the member of the board until he has got this knowledge. And in the opinion of central government, it is useful for the board. Now, again, very basic question, can this be asked in the exams? I would always say yes. So the whole management of SEBI would vest on the board, and this power can also vest on the chairman, except wherever this power has to be exercised by a majority of the board members, then it's fine. Otherwise, the chairman of the board has got all the powers to exercise whatever is given in the law. So the terms on the chairman and the other members who are nominated, it is 5 years, subject to maximum age of 65 years. And the chairman and other members shall have the right to relinquish the office anytime, whenever they want, before the expiry of the tenure, by giving a notice of 3 months in writing to the central government. So that facility is always available. And the post can be terminated also by central government. So the answer is yes, 3 months notice or salary for 3 months. So the government can give a 3 months notice, or they can give a salary in lieu for 3 months, and they can terminate that post. So can a member be removed? The answer is yes. So member can be removed. And when? When will he be removed? So he can be removed when he is adjudicated as an insolvent declared by the court. So currently under IBC. Unsound mind convicted by court involving moral turpitude. These are common points. I think this applies to every eligibility criteria across any act. So these three, I think you can always remember wherever there's eligibility criteria to be met up. Yes, this is something because here it is public which is involved. So central government is of the opinion that he's abusing power and continuation of office will be detrimental in public interest, because there's public involvement, and we believe that if this particular continues, then there may be certain issues which is detrimental in public interest, so it should be removed. And obviously, reasonable opportunity, ROBH. Remember this term which you are going to use time and again here. Reasonable opportunity to be heard will always be given. So one is termination, second is removal, and the terms of appointment. This is relevant for MCQ based question. Remember, for MCQ, these are all important points. So example, a group of complaints have alleged that Mr. Goel, a member of Securities, posed SEBI has pecuniary interest in some of the cases that came up before the court, and then he misused position, therefore he should be removed. The complainants seek your advice. The answer is yes, he can be removed because he has misused his position at the board, and therefore he can be removed. So the primary reason why it was set up to regulate, control the operations of mutual fund, to work as a regulator of the stock exchange activities, all of the above. So I think very clear. The whole purpose is to manage the intermediaries. So merchant bankers, mutual funds, stock exchange are all intermediaries coming within the ambit of SEBI. So all of the above. Yes, Mancha, I absolutely perfect. Social exchange. Social exchange is also there now. So a lot of things coming into action. Yes. So board consists of how many members from RBI? I think 2 members. That is what we have discussed. 1 member. Sorry. 2 members from Union Ministry and 1 member from RBI. Overall, it is 5, Janvi. Overall, it is 5, but 1 member from RBI, 2 from Union Ministry. The chairman and other members shall have the right to relinquish your office any time before the expiry after giving a notice of. That is very simple, 3 months, which is very standard. The chairman and the whole-time members may hold office for a period of 5 years. Again, very standard. Meetings of the board. Now, this is again important. Meetings of the board. The meetings will take place at such time and places, and they will follow certain rules and procedures which have been attached to this particular act and referred to in section 30, where the rules and procedure are given for conducting meeting, which believe is not required to be studied. In absence of chairman, any member can preside over the meeting after the member gets selected. And all matters shall be decided by majority vote, and chairman has the casting vote. And in a particular resolution where the members are interested, they will not participate. Now, this is important. Section 8. This you need to remember. It talks about that proceedings not to be impacted in case there is a vacancy. And that vacancy is creating any defect in the constitution of the board, in the appointment of any person, or in irregularity of the procedure of the board, and not affecting the merits of the case. So if that particular vacancy is because, let's say, a government has appointed 2 persons from RBI, which is not allowed, and a person has crossed the age limit of 65, which is not allowed, or let's say the person has resigned and there's vacancy in the whole board composition, then all these vacancies will not invalidate the acts of the board, only because the people were not there, so it will not affect the working of the board. So this is important theoretical question which may come in the exams. Under what circumstances the proceedings not to be impacted or vacancies not to invalidate the acts of the board. So please do remember this particular section 8. So defect in constitution, appointment, irregularity. RAD. Again, a lot of MCQs so that you are able to understand, correlate whatever you have studied. Suppose SEBI has constituted its board as per requirement of section 4 with 3 whole-time members under section 4(1)(d), but one of them resigned, and to refill his position, it took 1 month. Examine acts done in part between the vacancy period as per SEBI Act. All acts becomes void ab initio. Only financial acts are void ab initio. All acts are valid as per section 8. All acts should be rectified after composition of proper board. So all acts are valid as per section 8. That is what we have studied, correct? Any question which you have, please keep on raising. Powers and functions of SEBI. From here onwards, we have the importance of exams coming in. Exam-related question coming in. Powers and function of SEBI. Section 11 is the most important section, which will cover the powers and the functions of SEBI, distributed into different parts and different subsection. So section 11, as I told, it is the heart and soul of the act. Heart and soul of the act. And it is empowered to take preventive as well as punitive. Very important. It is entitled to take preventive as well as punitive actions, both. And the objective is obviously to PP. So here it is PPPP. Preventive, punitive, protect, to promote. Let us see what are the preventive and punitive measures. So one is power is very general. Then we have powers which relate to civil code powers, Then powers to penalize. Then additional powers under Securities Contract Regulation Act. Then power to investigate, cease and desist proceedings. This was asked in the 22 exams. Issue directions. Issue directions. So multiple power, multiple ways to protect and prevent and punitive. Now let us see each and individual area. First power is obviously to register and regulate. Register and regulate. Whom? Intermediaries. Register and regulate. Whom? Intermediaries. Then regulating the business in the stock exchange. Regulating the business in the stock exchange and any other security market. So we have now the social exchange, stock market. And this is again very important. I hope the presentation is visible. Any student can confirm, please. The presentation is visible. I thought there was some technical glitch coming in. So business in the stock exchange and substantial acquisition of shares, which is very important, friends. From all aspects, this particular guidelines and regulation issued by SEBI on substantial acquisition of shares under company law is very important. Please do read this. And then promoting self-regulatory organization like AMFI, Association of Mutual Fund of India. That is one association which is self-regulatory organization. And investors education and training of intermediaries of the security market. There are a lot of training programs which are conducted regularly. And this comes under the purview of SEBI. Even our institute also allows to conduct, programs for investor education. So these are all steps taken by SEBI to educate the investor. Then other powers include in case of specific situation, calling for information from any person, including any bank or authority or board. That means from anybody. They can call for information from anybody. And calling for information or furnishing information to other authorities, whether in India or outside India. So they can call for information and they can furnish information. They can furnish information also to other bodies who are having similar kind of functions across the world. And they have power to undertake inspection, conduct inquiries, audits of mutual funds, stock exchange, other persons, self-regulatory organization, and so on. So a lot of duties, a lot of powers, and these are exercised very diligently by SEBI. And it's not only in books, I think they take action on these points also. Then other powers include levying fees or other charges for carrying out the purpose of the section, conducting research for above purposes. Very good. So they may allow research also, which is very much required because that is where we are lacking in. But here there is a provision to conduct research. Calling from or furnishing to any such agencies as may be specified by the board, such information as may be considered by it for the efficient discharge of function. That's a very general clause again. And these are two residuary clause where they can provide information wherever required and perform such other function as wherever required. So I have segregated RRP, registering, regulating, promoting. Then with respect to calling for information and providing information, calling for information and providing information. and undertaking inspection and conducting inquiries. Undertaking inspection and conducting inquiries. Now, further moving, the other functions, other powers. Power with respect to inspection of books. Inspection of books and documents. So they have got the power to undertake inspection of any book, register, record, document of any listed public company, or record of any public company which intends to get listed. Is securities listed, right? Which intends to get its securities listed on any recognized stock exchange, wherever the board has reasonable grounds to believe that. So remember this line, any listed company or a public company which intends to get its securities listed. It is very common. It will come throughout this section 11 and so on. Throughout this section 11 and so on. So please note it down. It's a common statement. It's a common statement. So you will require to write it down at various provisions. So I would suggest that underline this, note it down, and learn this. Now, when can they take this inspection? Where they have been indulging in insider trading, which we will understand. A very common term used in newspapers. And fraudulent and unfair trade practices relating to securities market. So they have a power to inspect. Remember, power to inspect books of accounts. There will be certain confusing between the powers mentioned in a different section. Confusion will prevail. Civil code powers, I think I'm not going to discuss that civil code powers because it is very general, where whatever happens in court, those powers can be executed out here by SEBI. That means summoning, giving summon and enforcing the attendance of person, calling for information, issuing commissions or as per examination of witness, and so on. Now, what is going to happen? Once they do an inspection, or during the course of inspection, they come to know certain facts. So board may, by an order for reasons to be recorded in writing, in the interest of investor or security market, take any of the following measures, either pending investigation or inquiry on completion of such investigation or inquiry, namely, suspend trading of any security in recognized stock exchange. RAC is recognized stock exchange. Restrain person from accessing of security market. These are orders which they can pass, remember. So there have been n number of orders restricting people from accessing of security market. N number of orders. Suspend any office bearer of stock exchange. It has happened in some of the cases recently. Impound and retain the proceeds of securities in respect of any transaction which is under investigation. So they can have a control over all the amount which is in question during an investigation. Then attach bank account for a period not exceeding 90 days. Attach bank account. See the powers. Then direct any intermediary of any person associated with security market in any manner not to dispose of or alienate assets transaction during investigation. So when the investigation is being carried on, so remember what we have seen in 11.2.8 is about inspection, investigation, inquiry, which will come at a later stage, but then orders are given under 11.4. Orders are given under 11.4. Now, with respect to bank account, which we have just seen where these can be, attached. Provided further that only bank account or accounts or any transactions entered therein, so far it relates to the proceeds actually involved in violation of any of the provisions of this act, shall be allowed to be attached. That means the accounts which are used in this whole business by the intermediary, where actually funds have been received and dispersed. So only that bank account will be freezed. Otherwise, no other bank account will be freezed. The amount disgorged or they taken away shall be credited to the Investor Protection Education Fund. So one name of the fund which has come in, Investor Protection Education Fund. Or such amount shall be utilized by the board in accordance with the regulation. Such amount shall be utilized by the board as per the regulation. Decided by SEBI. So what they can do, these are the orders which they can pass with respect to the company ABC. So these are the power orders which they can pass. 11.4 orders. SEBI has undertaken inspection of books of accounts. Specify the measures which may be taken by SEBI under SEBI Act to protect the investor, protect the interest of investors and security market on completion of such inquiry. Now again, when they do the inspection, what finally they can do? Again, as we have studied only this much, so 11.4, even here also 11.4 will apply. So on receipt of, when they will receive the complaints, and based on whatever inquiry inspection they have done, then 11.4. After inspection, again 11.4 can be applied. The board may take measures to undertake inspection of any book or register or the document or record of all public companies, only listed companies, only listed unlisted companies, all listed public companies, and public companies which intend to get listed. So which is a correct answer? So obviously it is very clear. Fourth is the correct answer. Fourth is the correct answer. Prospectus. Very important. Prospectus. We all understand the purpose of prospectus, for what it is issued. Vansha, who is the regulator of the mutual fund? Regulator is SEBI. Mutual fund is not the regulator. SEBI regulates mutual fund. MFI is just an association of mutual fund to create, it's a self-regulatory organization, maybe to promote fair trade practices in the mutual fund industry. Yes, Mansha, this is relevant for November 2023 exams. So the board may, for the protection of investors, specify by regulation or by general or special orders. By regulations, when they will specify the matters in relation to the issue of capital, transfer of securities, and other matter incidental thereto, and then manner in which such matters shall be disclosed by the company. So, ICDR regulations have been framed. If you can recall, there is an ICDR regulation. There are different regulations issued by SEBI. So, ICDR regulation is with respect to issue of capital. So whenever the company comes out with an issue of capital, then they have to follow those ICDR regulation, and that will cover the issues related to issue of prospectus, because prospectus comes into picture whenever there is raising of funds. Then by specific orders, they may prohibit any company from issuing prospectus or offer document or advertising soliciting money from the public for the issue of securities. Or they may specify the conditions subject to which the prospectus may be issued. So either they can prohibit or they can specify the condition for issue of prospectus. So that is under general or special order. But by regulation, they have come out with ICDR regulations for managing the companies coming out with public issue. Then we have further powers to issue directions. Now, this is purely to give directions. And this will again, see, these are all powers which will exercise on certain events. So there is an event which is happening. Obviously, that event is a complaint received or some information received. And thereafter, they may conduct inspection, they may conduct inquiry, whatever. So after making or causing to be made an inquiry, the board is satisfied that it is necessary in the interest of investor. It is necessary in the interest of investor or orderly development of security market, to prevent the affairs of any intermediary or other persons referred to in section 12, which will see being conducted in a manner detrimental to the interest of investor, or to secure the proper management of any such intermediary or person. Then it may issue certain directions to any person or class of persons referred to in section 12 or associated with security market, or to any company in respect of matters specified in section 11A as may be appropriate in interest of investors in security and securities market. So whenever they feel that directions are necessary to prevent investor to secure IPS, interest of investors, prevent the affairs of any intermediary or other person referred to in section 12 being conducted in such a manner which is detrimental, or to secure the proper management of any such intermediary, where they would like to take the control of, not the, obviously SEBI will not take control of the management, but they will ensure the proper management of such intermediary, then these directions may be issued. Now in exams, there are direct questions which have come in with respect to what are the directions which SEBI can issue. So at times, as I said, there is confusion. There was power under 11.4 to give orders on account of inquiry, investigation. Now this is a power to issue directions. Power to issue directions. So don't get confused. Be clear in your mind the demarcation which has to be done, though there is thin line of differentiation. Now, there is SECRA Act. And under SECRA Act, the SEBI has got certain power. So this is not being given in SEBI Act, remember. These are the powers derived from Secret Act. So what we are mentioning, discussing out here is what are the powers for SEBI, whether mentioned under this act or under any other act. So we are deriving the powers of SEBI from SCRA Act. So it shall be open to SEBI to inspect all reasonable time books of accounts and documents to be maintained by stock exchange for a period not exceeding 5 years, which may be prescribed in the public interest and interest of trade by the central government. And SEBI may appoint any person to make an inquiry, and SEBI will bound the concerned person to produce documents before himself or any inquiry officer. So any questions? No. Great. Now, collective investment scheme. This is purely a separate section. And we just need to understand what is the CIS. A direct question on CIS, no technical question on CIS, collective investment scheme, which has been referred and could be termed as collective investment scheme. So yes, mutual funds are in the form of collective investment scheme, but because mutual funds are covered separately, so that is why we are assuming that CIS is referring to similar kind of schemes other than mutual funds, maybe. And the contributions payment are made to such scheme or arrangement by the investor to view to receive profits, income, produce, or property, whether movable or movable from such scheme. The property, contribution, or investment forming part of such scheme arrangement, whether identifiable or not, is managed on behalf of the investor, and the investor do not have day-to-day control over the management in the operations of the scheme. Now, if I want to refer to certain examples for CIS, if you are aware or seen in newspapers or somewhere, some hoarding in the city or some news about certain companies, there have been a lot of schemes which have been issued by various companies known as plantation scheme, where they say that we will collect money on your behalf, we'll plant certain trees, and after 15 years, 10 years, we'll refund after selling their trees. The tree will grow, and whatever proceeds will come out of these trees, that will be refunded to you. So to cover those type of schemes under the ambit of SEBI, this particular section was introduced. So one is purely defined CIS, and second is deemed CIS, where any pooling of funds under any scheme which is not registered with the board or is not covered are under exempted, involving a corpus of amount of 100 crore more shall be deemed to be a collective investment scheme. So anything which is not defined here, but then which involves pooling of fund and which is not required to be registered with the board for whatever reasons, but then the amount is 100 crore more, it will be deemed to be collective investment scheme. Whether they are required to be registered or not, that's a separate. So why they have been brought under the net? Because as going by the definition, it involves public money. That is why all these schemes have been brought under the net of collective investment scheme. Certain CIS which are exempted: cooperative banks, cooperative society registered under cooperative society, NBFCs because they also do the job, insurance companies, pension scheme, insurance scheme. These are also they are collecting money, so that will also not come under the purview of these CIS schemes. 58A, deposit scheme launched by company, Nidhi companies, chit business of falling under Chit Fund Act, mutual funds under which contribution made in the nature of subscription to mutual fund. As I said, though they are looking like a CIS, but then they are exempted. They will not be under the purview of Section 12. They may be covered elsewhere, but not for Section 12. So from exam point of view, what you need to do is just remember definition of CIS. What does CIS means? So contribution or payment made by investors by whatever name called are pooled. So one is pooled, word is pooled. Then contributions are made in such scheme to receive profits, income, produce or property. Then third, whether those properties are identifiable or not. And fourth, they do not have day-to-day control over the management. These are the four important. Pooling to receive profit, investment in identifiable or unidentifiable assets, but I don't have any control. These are collective investment scheme. Example I have given you, what could be an collective investment scheme. Green financing, climate financing is example of CIS. I'm not sure what does this relate to, but if green financing, what I understand is financing for any steps taken by any company for ensuring the sustainability. That may not come under the collective investment scheme because there's no such collection for generating income. Investigations. Now, somewhere we had seen that there's a power of SEBI to issue orders on account of investigations, inquiry, and so on. So the first step which will come in is to order for investigation. Orders will be issued after investigation under 11.4. But when will investigation happen? That is important. So let us understand the grounds for issue of an order of investigation. So 11.4 was talking about orders after investigation or during investigation. Here we are talking about before investigation, what should be the reason? And then there was another power for inspection of books and accounts. So that was different. So inspection is there, investigations are there, orders of during investigations or post-investigation are there. So whenever we have reasonable ground, fine, that the transactions in security market are being dealt with a manner detrimental to the investor or security market, or any intermediary, any person associated with the security market has violated provision of this act or the rules of the regulations made or direction issued by the board thereafter. So very general, whenever they feel not following the procedure or transactions are done in a manner detrimental to the investor or the security market. Now, when can the inspection be done? Let us do all and go back to section 11 and understand what is the difference out here. Here it was specific on a listed company or public company where there's insider trading or unfair trade practice. Now, and it is applying to listed company and public company, while here it is applying to any intermediary or any person. So here there is no such listed company or companies which are intending to come out in the market for issue of shares. It is in relation to the transactions which are happening in the stock market. which may be unfair, and for that the public company may be involved, right? But then they are referring to transactions or to intermediate brokers, mutual funds, depositories, as it happened with Carvey. It was a depository. So under these grounds, at any time by order in writing, direct any person specified in the order to investigate. That means they will appoint an investigating authority to investigate the affairs of such intermediary or person associated with security market and to report thereon to the board. So now a person will come into picture, investigating authority. Investigating authority. So once he is appointed, thereafter, what is going to happen? So now the process of investigation is going on. Process of investigation is going on. So it shall be the duty of every manager, MD, officer, other employee of the company, and every intermediary referred to in this section 12. So section 12 talks about registration of all the intermediaries. So they have given a list. Yes, registration of intermediaries, section 12. So it talks about all the intermediaries to be registered with SEBI. So I'm not going to details of those intermediaries, just refer section 12 is basically section for registration of intermediaries. So all the person referred to in section 12 or every person associated with security market to preserve and to produce to investigating authority or person authorized by it, all books, registered documents or record relating to the company, or as the case may be relating to the intermediary or such other person which are in their custody or powers. So they have to produce the books of accounts, books, registered and other documents. And thereafter, when they produce the books of accounts, the investigating authority may in its custody keep the books, other documents for 6 months, and thereafter shall return the same to any intermediaries after 6 months. And if they require, if required, they may call for the records again. And if required, they may require the certified copies of the books. Then the investigating authority, it shall give certified copies of the books, which means that within that 6 months, if the person from whom the books were taken, the company, they require certain documents for any other purpose, then the investigating authority can give the certified copies of such books of accounts. Thereafter, what the investigation authority can do: examination on oath. Any person directed to make an investigation may examine an oath, manager, MD, officer, and other employee. That means they can be called and say that whatever is speaking are correct, and they can record all things on writing. And if they necessary, they may call that person personally. Required, they may call that person personally. Notes of examination to be used as examination. Notes of any examination shall be taken down in writing, shall be read over to, by, and signed by the person examined, and may thereafter be used as evidence against him. Consequences on failure of compliance. Failure in compliance to produce to the investigating authority or any person authorized by it in behalf of any book, register, or other document, a record to which is duty to produce or furnish any information which is his duty to furnish, to appear before the investigating authority personally to answer to any question, or to sign the notes of any examination. So if you fail to comply with whatever the investigating authority is required to do, where what we have studied in 11C, to produce books of accounts, come personally, examine on oath, sign all whatever you are saying, then he shall be punishable with. So in exam, the question is, what are the powers, under what grounds the investigations will be issued, and what are the powers for the investigating authority? And third question, what are the consequences on failure of the compliance? So he shall be punishable with imprisonment, with fine, which may extend to 1 CR or with both, and further fine which may extend to 5 lakh rupees for every day after the first during which the failure or refusal continues. So this 11C section is very common, very important. Powers of investigation of SEBI. Powers of investigations of SEBI. Further, where in the course of investigation, the investigating authority has reasonable ground to believe that books, registered documents, and record of or relating to any intermediary or person associated with security market. Again, this is a common statement which is coming. First was public companies, and public companies in which is intending to list its shares in the security market. That was a common statement. Or here, any intermediary or person associated with security market in any manner. And when they feel that it may be destroyed, mutilated, altered, falsified, secreted, the authority may make an application to magistrate or judge of any court in Mumbai as may be notified for the central government for order of seizure of such books. So he can impound, seize the books. Seize the books whenever he feels that it may be altered, mutilated, destroyed. And in doing so, if it requires the assistance of other people, he will definitely apply to the magistrate that I would require support of A, B, C, D people. Please provide me proper support so that I can go and impound the or seize the documents. So after the application is heard, and the judge may give the orders, necessary orders, and then accordingly the investigating authority may take action. Now, in exam, the specific question will be, what are the powers of the investigating authority for seizure of documents? For seizure of documents. That could be a separate question. One was powers during investigations or of investigation, and then powers for seizure of documents. Now, once they have seized, is it like that they will keep the books forever? Okay, no. They may keep in custody the books, register the documents for a period not later than the conclusion of the investigation as it considers necessary. And thereafter it shall be returned to the company or to the MD or the manager or person who has been involved in this whole process. So they will keep it not forever, but till the conclusion of the investigation. So 11C, quite common, very frequently asked, and because of this power of 11C, people are very cautious. They take note of all things, and we're very vigilant whenever this investigation comes from SEBI. Now, along with 11C, there are certain powers which is more of a preventive power. We have seen that preventive preventive, punitive. So here we are talking about some preventive powers of SEBI, which are known as C and D proceedings, which are known as C and D, cease and desist, C and D proceedings, cease and desist proceedings. So if the board finds that after causing an inquiry to be made, so after an inquiry, any person has violated or is likely to violate, then they may pass an order requiring such person to cease and desist from committing or causing such violation. So if they think that person is going to come in the market and then those steps taken by that person may be detrimental, so the order will be released to prevent that person coming in the market. And let's say for a company which is trying to come out with a public issue, can they prevent the company from coming out with a public issue? The answer is no and yes. No, because the board shall not pass such order in respect of any listed company which intends to get its security listed on any recognized stock exchange, unless you have got reasonable grounds to believe that such company is being indulging in insider trading or market manipulation. Insider trading or market manipulation. One thing is very logical. I think a company whose shares are not listed, they cannot be indulging in insider trading of their own company shares. That is true. But they can be involved in insider trading of other company shares. Now you would say, sir, how? Why? Why they will involve in insider trading of other company shares? For that, let us understand insider trading. What happens in insider trading? So insider trading is such kind of transaction where you form a cartel of people, or not a cartel, or let's say, where you trade in securities and you have got, when you are doing the trading is done because you have got certain information. Now in a efficient capital market, we know that all information is available to all at all times at the same time. But insider trading says that a particular segment of people receive information prior to what is being received in public domain. And because you have received information prior to what has been published in a public domain, and you have involved yourself in trading of those securities, those transactions will be termed as insider trading. Those transactions will be termed as insider trading. So I hope the insider trading concept is clear. What does insider trading means? And there have been many cases of insider trading. There have been many cases of insider trading, and a lot of orders have been passed against people who have been involved in insider trading. Or market manipulation. Now, what does market manipulation means? Market manipulation means where you jack up the prices of certain shares by forming a cartel where you have buyers and sellers who know each other. They form a cartel and they decide that I will sell, you will purchase, I will sell, you will purchase. And in doing so, they create an artificial demand of those stocks, which increases the stock prices of those companies, thus giving benefit to few, attracting people to the trading and towards that company. And after that, when public at large start trading in those securities, they dump the shares. And suddenly the stock prices goes down, because of which the normal investors incur losses, and they had no information of why these stock prices were going up. This was because of the manipulation done by a few people who came together and artificially increased the prices of certain shares. So if the SEBI thinks that these are the transactions which are going to happen, then they will give an order for preventing such transactions from happening. Now, this was recently introduced, 12A, which relates to something of technology and trading in the stock market. Today, trading in the stock market has become a function of technology, sourcing information, and based on certain predefined trigger events which are generated by computers at the trading terminals, and based on that the transactions happen. So if you are aware of the transactions happening in the stock market, you'll find that these prices fluctuate within microseconds. And as an investor, if I do a transaction even 0.01 second prior to other people coming to know of any such kind of event, transaction, information, then I could gain a lot. And doing a transaction 0.01 second prior to what people can do may be a possibility. That's what SEBI had explored, and that is why a lot of investigation had been carried on, where it was found that few of the brokers could trade in the market 0.01 second earlier. Example, I don't know the precise time, because they had certain devices installed, and because of those devices, it gave them the extra benefit. So because this came into picture during an investigation or information, so this particular section was introduced recently, about 2-3 years back, where no person shall directly or indirectly use or employ in connection with issue, purchase or sale of any securities listed or proposed to be listed on a stock exchange a manipulative or deceptive device or in contravention of the provisions of the Act, or they employ any device, scheme or artifice to defraud in connection with issue or dealing in securities which are listed or proposed to be listed on a stock exchange. So using any device, any instrument which can give you an extra benefit to manipulate the price, then it is not allowed, because trading in a stock market is a complicated game. As a retail investor, we are trading in what minimum 100 shares, 500 shares, 1,000 shares, 2,000 shares maximum, as a retail investor. But look about the volumes which happen in bulk, where lack of shares are exchanged, purchased, sale within microseconds. So even if a difference of 1 rupee in a 0.01 second can turn out to be in a huge loss or gain for any person if the volume is high. And because of the world of technology, a lot of things are possible. So therefore, this section is very important. Please remember a device section, a section of device, which I found which is nowhere else in any other act. So this is a unique section specific to SEBI, specific to intermediaries and people who are involved in listed trading in the listed market. So device section, exceptionally a different section. Do remember, don't miss out on that. Further, these devices, they are engaged in any act, practice, course of business which operate as fraud or deceit upon any person in connection with listed securities or whatever, engage in insider trading, deal in securities while in possession of material or non-public information, or communicate such material non-public information to any other person. So in a lot of cases, what happens, friends, as per listing obligations, the listed company have to disclose certain information to the stock exchange. So the whole process is the information is first floated in the board meeting. The board meeting will conclude and the compliance officer will upload those outcomes of the board meeting on the stock exchange. The stock exchange will again publish those information in the public domain as soon as it is received from the company. This whole process is through a technology. And if it is happening during market hours, and if I get information prior to, not prior, that means not from the company, but when it is being uploaded. So the moment it is uploaded, I get information 0.1 second earlier. It can make a lot of difference. Or they acquire control of any company or securities more than the percentage of equity share capital of the company whose securities are listed. Then again, this will come under this purview. So 12A is now very active and quite pervasive. That means it has covered a lot of many transactions. Registration of IM, I've already discussed, not required to be studied from exam perspective. Finance and accounts. Finance and accounts in relation to SEBI. So what we have studied till now is more of powers, investigative powers, investigation, 11C, just the newly introduced section 12A, 11D, C and D. 11D is C and D. And then 11.4, power to issue orders, give orders, general orders, whenever, whatever can happen. So they will give orders under 11.4. And then collective investment scheme, CIS. What is the power of SEBI under those CIS? So within this particular thing, I think that direct question will come. Yes, Mancha, correct. This section was introduced after the NAC co-location case. That is why I said it was recently introduced, and there's co-location case still going on. And this was on relation to technology and related transactions. With respect to whatever you have mentioned regarding the investigation of a particular group, I cannot comment on the same, as things are under these are all being carried on. So let us state for the final state outcome. Then obviously that can be studied, whatever the SEBI gives as an order. Finance and accounts. Okay, fine. Now, how does SEBI functions in terms of financial? From where does it receive money? So it receives grants from government. And if somebody is giving grant, obviously it will ask for information, utilization of the fund. So it's an SEBI general fund. It shall be credited with all the grants fees received by the board under the Act. And they shall be applied for salaries, expenses, and expenses on the objects of the Act. So a lot of fund is allocated towards this SEBI. Then accounts and audit. So accounts will be prepared, preparation of annual financial statement of board in consultation with government will be done, as it happens with all other agencies. Same thing will be applied, no difference. It will be audited by the Controller Auditor General of India. It will be presented to the board, and then all the certified copies of the accounts will be forwarded to the central government. The most important of all the provisions for SEBI: penalties and adjudication. Penalties and adjudication. We have seen practical questions coming out of these particular section, which will cover different scenario of penalties, and we'll understand each of the penalty in detail wherever required, and understand the transaction, basic underlying transactions, where for what reason the penalty is being imposed upon that particular person. So this penalty section is covering from 15A to 15HB, and section 24 separately, which talks about again penalty, because under section 11 we have seen the SEBI can impose penalty. It has got the power to impose penalty, and under section 15 the penalty is being imposed. So there are two challenges. The first challenge is for what reason the penalty is imposed, and the second challenge is how much. So in most of the cases, the amount is same, most of the cases. So that brings us certain kind of comfort level, relief, which is a big challenge, remembering all the penalties. So the second channel will remain that for what reason the penalty is being imposed, and the section number. So maybe we can, if you think that you are capable, then do learn the section numbers. But then general section is section 15. General section is section 15. Remember that. So let's start with each of the section. 15A. The first one is 15A. Which talks about if any person. In most of the courses, you have seen that SEBI covers any person. So we are not trying to limit, except in one scenario where it was restricted to inspection of books of accounts, only restricted to public company or company which is intending to list its shares. So if any person fails to furnish any document, return or report to the board, fails to furnish the same, he shall be liable to. So the first is very general. When you are called for information and you are not submitting any information. Now we have seen there was another section which was talking about failure for not providing any information. Punishment was there during investigation, but that was specific during investigation. Now what we are talking about here is under any rule or regulation. So it's not only about investigation, it is under any rule or regulation. So whenever you feel that under any rule or regulation, any information was required and you are not submitting those information, 1 lakh to 1 crore is a standard one, remember. What is that 1 lakh to 1 crore? So minimum 1 lakh. And thereafter, it will be 1 lakh per day, subject to maximum of 1 crore. This is what you have to remember. 1 lakh minimum and 1 lakh per day, during which this failure continues, to maximum of 1 CR. Great. Then, under same section, if he files any return or furnish any information, sorry, he not he files, but he was asked to file any return or furnish any information within the time specified, but fails to file return or furnish the same. So one is furnish any document, return or report. Second is fail to file any return or books. Then same. And third, he fails to maintain books of accounts or records or fails to maintain the same penalty. So 15A is about failure for document, books of accounts and return. For documents, books of accounts and return. (15B), any person, again any person who is registered as an intermediary now. So 15A was talking about any person, no such criteria, but 15A is now targeting to intermediaries. Targeting to intermediaries. Enters into an agreement with his client, or where it is required to enter into such agreement, but fails to enter into such agreement. Now, what could be this possible scenario? If you are trading in the stock market, then you will know that you open an account with the broker, and normally broker will make you sign many documents. Broker will make you sign n number of documents, and during that n number of documents, out of the n number of documents, there is one document which is an broker-client agreement, which is mandated by SEBI to be obtained by the broker from the investor. And if the SEBI finds that these agreements are not being taken, then penalty 1 to 1. 1 to 1. 1, 1, 1. 111. We'll name it as 111. 1 lakh minimum, 1 lakh each day, maximum 1 crore. So 111. So 15A was calling upon each person to furnish, and 15B is targeting person, any person, but specific to the world of intermediary, where you're not entering into any agreement, which was required to be done so. 15C. 15C. If any listed company or any person registered as an intermediary, now we are adding any person and a listed company. If they fail to redress the grievances of the investor within the time specified, then 111. Now, what happens in this whole process, friends? The world of listed companies is quite complicated. We all know that. And we know that there is an investor grievances cell under a corporate governance. There's a requirement of keeping an investor grievances cell and then updating the same to the board, and the board has to report to SEBI on a quarterly basis. Number of complaints received, number of complaints disposed of, number of complaints pending, the type of complaint, the nature of complaint. The same will happen with the intermediary also. And if you fail to do so, penalty will be imposed. So that is why the importance of professionals, the compliance officer, is very high when it comes to listed company, friends. Non-compliance of even a small step can lead to heavy penalty. The next one, D, where you have to obtain a certificate under Section 12 or CI scheme. Remember, and if you are doing any such function without such obtaining such certificate, then 111. 111. So no registration, then 111. Or even if you obtain a certificate but fails to comply with the terms and conditions of certificate of registration, then also 111. Then also 111. Then also 111. Further, if you are registered, but you do not list the schemes as provided for in the regulation governing such listing, then also 111. Then also 111. So quite a complication situation, friends, for companies who are coming under the net of collective investment scheme, not registered, not complying, and not listing the schemes. And the fourth, when you are failed to dispatch unit certificates of any scheme in the manner provided in the regulation. For each particular scheme, remember, when you apply in such scheme, normally what you get unit certificates. And they are being sent to you in the current environment, sent through your electronic mode. So if you don't receive such unit certificate as you get in the shares in your demat account, if you don't get such unit certificates, then again 111. This is all with respect to CIS. And if you receive money, if you have given money and you are not allotted any unit certificate and you don't get the refund amount from that CIS, then also 111. So for CIS, friends, there are 5 things. No certificate, failure to comply with terms and conditions, do not list, do not dispatch the unit certificate, and do not refund the money. Under all of the scenarios, 111 is going to apply. 111 is going to apply. Then we have the asset management company. Now, what is an asset management company? Again, I believe that you are aware of the mutual fund industry, the way the mutual fund industry operates. So the mutual fund industry is in the form of a trust. We have a sponsor who creates that, who is the beneficiary, who comes in, there's a beneficiary, and they receive the money from investors. And this whole money is managed by a company known as asset management company who will invest in the market. What is similar to KYC, Mancha? I did not get. Who will invest in the stock market. So the whole job of investing is done by the asset management company. So they are part of the mutual fund industry. So they can be regarded as a person associated with the mutual fund industry. So they are one of the intermediaries. So when they fail to comply with any regulations providing for restrictions on the activities of AMC, So when they are performing and there are certain activities which are restricted, but they continue to perform in spite of the restriction, they will be liable to penalty. So normally AMC are subject to, limited area of working, that they will work only for investment on behalf of certain mutual fund. And if the mutual fund has issued certain schemes of specific nature, they will observe the guidelines of the scheme and accordingly invest in the market based on the scheme objectives. So there are restrictions on how the asset management company can operate and invest. So if a scheme is directing towards investment in, let's say, banking industry, so they have to work under the purview of banking industry only. But if they fail to comply with certain restrictions, then penalty will be issued. Again, it is a newly introduced section with the invention of new types of, investment opportunities and new types of investment securities coming in the market. So AIF is alternative investment fund and similar kind of RETs relating to real estate investment trust and similar to technology related IIT funds. So these funds are now very common. IIT is infrastructure fund, sorry, not in technology fund. Infrastructure investment trusts. So where we have investments fund, real estate investment trust or infrastructure investment trust, which come out in the market. And in the last 5 years, there are a lot of REIT, infrastructure investment trusts, REIT and infrastructure investment trust coming out in the market and raising funds from the public and investing in the market through some different mechanism. So these are again people who have to get themselves registered with SEBI. So this is now targeting specific type of trust. And when they fail to comply with the direction issued by board, so again, same kind of penalty. But here, because they are investing, and if any failure results in a gain to that particular trust, that is the limit of penalty amount. So here there's a difference. So here the difference comes from 15EA, where penalty can be 3 times the amount of gain made out of such failure, whichever is higher. So out of 1 crore, 1 crore, or 3 times the amount of gain made out of such failure, whichever is higher. So the first time, now there is a difference in the penal amount. In the last 15 years, again, we have seen a lot of investment advisor mushrooming up, research analysts mushrooming up, who are becoming quite prominent for advising the investor of investing in the stock market. Where should they invest in? What is the time period? When to buy, when to sell? And these are the people who have to get themselves registered. So now we understand the gamut of intermediaries who are involved in this particular market. So again, they have to register, and if they fail to comply with the regulations, 111. So till now, only these are subject to different penalty. Otherwise, everybody is falling under the one figure of 111. So these are all newly introduced sections in 15EA, 15EB, which is in relation to 15E. Now, why 15EA? Because AIF, REIT, IIT, they're all similar to asset management companies. So that is why they have been further extended from 15E to 15EA. And advisors are also the same, the profile is same as asset management companies. So 15EB. So initially it was 15EF, but then because of the changes, the developments, 15EA, 15EB. Now for stockbrokers, specific intermediary stockbrokers. When they fail to issue contract notes. Now again, we all understand when we do a trading in the stock market through the brokers have to issue the contract note desired or in the structured form and manner, and that too within a particular time period. Within a particular time period. And here, the penalty is something which is different. So I'll talk F with foolish. F with foolish. Foolish penalty. Because here the penalty amount will be minimum 1 lakh, but which may extend to for which the contract note was required to be issued by that broker. So maximum is the amount of contract note for the amount of contract note for it which was to be issued. So if I have done a transaction of 10 lakhs, if the contract note was of 10 lakhs, but they don't issue within time period, so the penalty can go to 10 lakhs, 50 lakhs, 1 crore. You never know. So I'll term it as a foolish section. So because it is different, so remember 15 as a foolish section. Further, if he fails to deliver any security, one was the contract, fails to deliver any security, fails to make up the payment of the amount due to the investor within a time period specified. So scheme is the penalty amount is 111. Or he charges an amount of brokerage which is in excess of the brokerage specified in the regulation. 1 lakh, but which may extend to 5 times the amount of brokerage charge in excess of the specified brokerage, whichever is higher. So F is a typical foolish section, which will talk of different penalty. In case of contract note, we have seen it is to the extent of the amount of contract note. If it is for the brokerage which is being charged, which is not as per the regulation, then 5 times the brokerage or 1 lakh, whichever is higher. And if he fails to deliver any security or fails to make the payment which is required, then the normal penalty of 311. Now, fails to deliver any security means what? As an investor, I have purchased the shares. As an investor, I have purchased the shares. So I should get the shares within the cycle of settlement of T+2, and then thereafter, whatever time it is required to get the shares transferred to my demat account by the broker. We all understand the process of when you purchase, how much time does it take to transfer the shares to your demat account. Shares should come to my demat account. Or if I have sold the shares, I have to deliver the shares to the broker, and thereafter I will receive the amount which has been received against that sale of shares. So again, that is to be done within a time frame, and if it is not done, then the broker is liable to the penal consequences. So F, a different section. So please do remember the different penalties. Penalty for insider trading. I've explained what is insider trading, and you can understand that there are a lot of instances, lot of sections which refer to this word. Therefore, obviously, the penalty cannot be 111. Penalty cannot be 111 because it's a section which leads to gain to few specific individual. So how can you impose a penalty of 111 only? So any insider shall be liable to penalty more than 10 lakh extending up to 25 crores or 3 times the amount of profit made out of insider trading, whichever is higher. So again, a different section. Obviously, because of the nature of fraud involved. Yes, Mancha, it may refer to the agreement of KYC and other related compliances that because you are entering a transaction on behalf of the investor in the stock market. So SEBI has prescribed certain guidelines. So there are a lot of clauses inserted in that agreement with respect to the trade. So it includes KYC as one of the elements, but there are certain elements. Private equity, if it is in the form of alternative investment fund, venture capital, yes, venture capital have to register themselves with SEBI. 111 is minimum 1 lakh, thereafter 1 lakh per day, and maximum is 1 crore. That is 111. 111. Minimum 1 lakh, thereafter for continuous default 1 lakh per day, maximum 1 crore. Okay, so penal provisions with respect to insider trading, as I mentioned that because it's a fraudulent transaction or transaction with intention to gain a higher gain in comparison to what would be gain is for a normal person. So it communicates it's a transaction which is either on his own behalf or behalf of any other person, communicates any unpublished price sensitive information to any person with or without his request for such information, counsel or procures for any other person to deal in any securities of any body corporate on the basis of unpublished price sensitive information. So insider trading is basically communicating any unpublished price sensitive information to any person. With or without his request for such information, counsels, whether he has made a request or not, he advocates for it or not, doesn't matter. Or procures for any other person, whether you have procured information for any other person to deal in any security. And when you deal in such securities on the basis of these price sensitive information, other than in the normal ordinary course of business, then penal provision would apply. 15G. So F and G are a bit different part. F and G are something which are different. H, which talks about non-disclosure of shares and takeovers. Non-disclosure of shares and takeover. Which we have seen that we are, not studied, but I believe that it's an important rule with respect to Companies Act. The takeover guidelines, where there are different trigger points. When a company is taking over other company through the stock market, and if they reach to a particular level, let's say they acquire 5%, thereafter I think 11%, 15%, and so on, they have to take certain action, the acquiring company. So if they fail to take those required actions, disclose the aggregate of shareholding in the body corporate before he acquires any shares of that body corporate, or makes a public announcement to acquire share at a minimum price, or make a public offer by sending letter to offer to the offer letter of offer to the shareholders of the concerned company, or make payment of consideration to the shareholders who sold their shares pursuant to the letter of offer. So if he fails to do this, again, it's a big default, 1 lakh to 25 crores, or 3 times the profit made out of such failure, because it may lead to heavy gains for the person who is not complying with the rules. So whenever the transaction amount is huge and the stake is high, the penal amount is high. So 15 FGH, FGH in continuation, they talk about different penalties. So here we take a short break, friends, and after the break, we'll try to complete this whole concept of SEBI. and then the small sections of SEBI. So 15H, we have seen now understood with respect to the non-disclosure of acquisition of shares under the SEBI guidelines. Then if you are involving into fraudulent and unfair trade practices, then it is very natural that the penal amount has to be high. So you cannot restrict it to small amount. So one of our fraudulent and unfair trade practices, 5 lakhs to 25 crores or 3 times the amount of profit made out of such practices, whichever is higher. So 15 FGH. Where there is no such penalty being provided, then 1 and 1, not 111, but 1, but which may extend to 1 crores. All amounts received through penalty will be credited to Consolidated Fund of India. So 15GH, remember these are different, but rest till G, it is same. 15E is again applying to asset management company, REIT, and so on. So 15E is different with respect to the application. 15FGH is different with respect to the amount. And from 15A to 15D, the amount remains same. This is again an important information, friends, which was introduced in 2019, where if anybody tampers with information to obstruct an investigation or destroys regulatory data, that then the entity could be penalized up to 10 crores or 3 times the unlawful gain. Now, this was because newly introduced, because of certain findings during an investigation. So again, the amount is very huge. So recent amendment, which leads to penal provision of 10 crores or 3 times the unlawful gain. Now, some other powers of SEBI with respect to adjudicating power. When they have to impose penalty under all these sections, the board shall appoint any officer to be an adjudicating officer for holding an inquiry in the prescribed manner, so that a reasonable opportunity can be given to the person to whom the penalty is imposed. So now we have the adjudicating authority coming into picture to adjudicate how much penalty should be imposed. So penalty is defined, but the range is given. So what should be the exact penalty? For that, an adjudicating officer is appointed. He will hold an inquiry, and obviously, when he will hold an inquiry, he has the power to call, summon, and produce any document which may be useful for adjudicating the amount of penalty or in the inquiry. And even during this, if he fails to comply, he can be imposed such penalty as the adjudicating authority may think. So the power of adjudicating authority is to impose the penalty under those sections. For that, he can conduct an inquiry. Now, this is again a very important section, which is again asked in the exams, where the board has the power to call for examine the record of any proceeding, and if it considers that order passed by the adjudicating officer is erroneous to the extent it is not in the interest of security market. That means what will happen under this case, try to understand. It is talking of an erroneous order only in the interest of security market. That means interest of the revenue, where the board may think that the penalty imposed is less. Probably they want to impose a higher penalty. Under these circumstances, I think this section gives the power to board to enhance the penalty. Enhance the quantum of penalty if the circumstances of the case is justified. But this has to be done within 3 months from the date of the order passed by the adjudicating officer. So that's a limitation. Now, when the penalty is imposed, obviously there should be certain grounds on which the penalty can be imposed. So, obviously, grounds in the sense, what criteria should he consider for imposing a penalty? What criteria should he consider for imposing the penalty? So it should be the factors which should be considered should be the amount of disproportionate gain or unfair advantage, if quantifiable, which is very difficult at times to quantify. What could be the amount of gain he has made? There are 10 number of people who made the transaction. How can you quantify gain done by each person? Very difficult at times. Or the amount of loss caused to an investor or group of investors as the result of default. So calculating the loss, again, very difficult. And the repetitive nature of the default. How many times the default has been made? For example, SEBI received complaints from some investor. This is we have already discussed. Forget it. Okay, here are some questions. Here are some questions which are important from penalty point of view. So ABC Chartered Accountant is a partnership firm. It relates to a CA firm who is the auditor of one of the listed companies for the financial year 2018-19. Mr. B is engaging partner of audit with a team of 15 members. While doing the audit financial statement of the company, 2 members of the team were chartered accountant pass the information to their friends and relatives that this year the company profit is increasing by 25% as compared to the last audited financial year, and before this information came into public domain through the company. They made profit from this information by purchasing at low price, and after financial statement came in public domain, the share price is raised and they sold the shares at enhanced prices. Please state whether it is a case of insider trading. If yes, how much penalty? So is it the case of insider trading? The answer is yes. What is the penalty amount? So penalty amount is obviously 10 lakhs, which may extend up to what? 25 crores or 3 times the profit, which is derived, whichever is higher. It cannot be whichever is lower. So very explicitly, whichever is higher. So C is the correct answer. If any person fails to, without reasonable cause, or refuses to produce the investigating authority any record, he shall be punished with. Now, this is with respect to investigating authority. In section 11, we have seen, and if he fails to produce such information, then we have seen that there's an imprisonment, a fine up to 10 crores, and default of 5 lakh rupees each of the day. All of the above. All of the above. So if any person is required to do under this act any rules and regulation made there under fails to, he shall be liable to penalty of not less than 1 lakh rupees each day and 1 crore. So 111, furnish any document, file any return, maintain books of accounts. All of the above. Then, if any listed company or any person is registered as an intermediary fail to redress the grievance of the investor, he shall be liable to penalty of what? Grievances. So again, it is liable to penalty of, though amount has been mentioned. So I would assume that there is some mistake in this question. Please ignore this. Fails to deliver any security. Fails to deliver any security. Then penalty of, again, very difficult to remember, but then fails to deliver any securities, penalty of more than 1 lakh, which we extend to 1 lakh for each day, and maximum of 1 crore. Maximum of 1 crore. Now settlement proceedings. Settlement proceedings. Now what are settlement proceedings? Now, because penalty amount is huge, penalty is huge, and if there is a possibility of penalty settlement, why can't it be done? So any person against whom any proceedings have been initiated or may be initiated under section 11, 11B, 11T, subsection of 12 or 15I. So under penal provisions, there is a specific section of 15I only. Or if any under 11, 11B, these are specific section. 11D is ceased and desist. Then he can file an application writing to the board proposing for settlement of the proceedings initiated or to be initiated against alleged faults. The board may consider the settlement and settlement will be done as per the rules and regulation, and no appeal will be preferred. So in exam the question is whether settlement can be done under SEBI rule. Whether settlement can be done under SEBI rule. So the answer is yes, settlement can be done. So under specific sections, remember, under the specific section, the settlement can be done. Not generally at each section, but only under specific section, the settlement can be done. Now we come to SAT. SAT is nothing but a Securities Appellate Tribunal. Securities Appellate Tribunal. That means if you are not feeling comfortable, if you think that the order given by SEBI investigating authority is not as per your needs or as per your requirement or is not justified, then you can file an appeal under SAT. Under SAT. So how do I file an appeal under SAT? Let us see that. So they will establish a tribunal known as Securities Appellate Tribunal to exercise the jurisdiction power and also give the jurisdiction or the places where the SAT may sit. So the SAT will be constituted by a bench with 2 or more judicial member or technical member. These are all relevant for MCQ. Provided that every bench shall include at least 1 judicial member and 1 technical member. The benches of SAT will sit at Mumbai, and the presiding officer may transfer a judicial member or technical member of SAT from one bench to another bench. Qualification appointment of presiding officer, again, nothing but except you have to learn it. So any person who is appointed as a presiding officer or a judicial or a TM unless he has been judge of Supreme Court, Chief Justice of High Court, or judge of High Court for at least 7 years, or has been a judge of High Court for at least 5 years. In case of technical member, he has been Secretary, Additional Secretary, Minister of Department of Central Government or equivalent post in Central Government or State Government. And proven ability, integrity, standing of having special knowledge, professional experience of not less than 15 years in the area of financial sector, including security market and so on. The technical member shall be appointed by central government on the recommendation of these many persons. So I think, again, I'm not discussing all these provisions regarding the constitution of the bench of SAT and the qualification which is required to be a technical member or a judicial member. This you can learn anytime from anywhere. The term and the period of the members, again, clearly defined. It should be a term for 5 years and eligible for appointment for another term for maximum 5 years. So maximum is 10 years. And the age is 60. Remember, for SEBI board, it was 65. So SEBI board, it was 65. Here it is 70. Disqualification. A member, a part-time member of the board or an IDA or the pension regulator, you can ignore this, right? Nothing to read on this. So please ignore all these points. Removal, yes, you can be removed from this post. So either you can resign on your own and you can relinquish his office. And for this specific time period has been given. So my request is, again, these are all provisions which you can study at home. Removal of the presiding officer, judicial member, technical member, again, it can be done under specific situation. One is purely insolvent, second is not a fit person, and moral turpitude and detrimental to the public interest. So in all these cases, he shall be removed, which is common again. Now, this is important. This is exam related question. Who can file appeal to SAT? Who can file appeal to SAT? So, any person who is aggrieved by the order of board under section 11C, 11D, or by an order made by an adjudicating officer, remember, who is appointed to adjudicate the penalties, or by the order of IRDA, pension fund and development authorities. So remember, any appeal under those regulatory agency, insurance and pension fund, for that also SAT is there. Appeal shall be filed within period of 45 days from the date of the copy of the order made by the board. And even after 45 days, it is satisfied that there was sufficient cause for not filing it within that period. So even after 45 days, the appeal can be filed. Then the appeal shall be dealt with, and the time period to dispose of the appeal is 6 months. So 45 days to 6 months is the time period to dispose of the appeal. "45 days to appeal and 6 months to dispose of." Now, what is the process to be followed for by the SAT And remember, SAT shall not be bound by the procedure laid down by the Code of Civil Procedure. But because they have to apply natural justice, therefore they are allowed to regulate their own procedure, including the places at which they shall have their sittings. But what we have seen, they'll follow the normal court procedures, where they can issue summon, issue commission for examination of witnesses, reviewing a decision, dismissing an application for default, or deciding it ex parte, and so on. So same as whatever power the NCLT has, same powers has been given to SAT. These are all appellate tribunals. So obviously they have to be at same level. So 45 days from the date of order, appeal can be made. 6 months is the time period within which the SAT has to give their orders. And they are not allowed to, they may follow their own procedure and guidelines for reaching out to a particular decision. Every proceeding before a SAT shall be deemed to be judicial. That means the whole process of judiciary has to be followed. You cannot violate those provisions. And because there are multiple benches, so the presiding officer has the power to distribute the cases under SAT to which bench, and if required, the cases may be transferred also between 2 benches. This is again important. If the bench of SAT consisting of 2 members differ in opinion and in point, it shall state the points on which it differs and make a reference to the presiding officer for SAT, who shall either hear the point himself or refer the case for hearing only on such points by one or more of the other members of the SAT. And such points shall be discussed according to the opinion of the majority of the members who have heard the case, including those who first heard it. So this is an exam question. What if there is a conflict between the opinion of the presiding, between the members sitting at the tribunal? So how that will be resolved? So it can be resolved when it is referred to the presiding officer, and the presiding officer can refer the case to any other member who is sitting at the bench, and thereafter the majority will prevail. But that majority will consider only those people who have already heard the case. Again, an exclusivity which is given to the SAT and the powers of SAT, that civil court will not have jurisdiction over any particular proceedings carried out under the SAT. So if you are agreed with the order of SAT, then the direct provision goes to Supreme Court. The only channel goes to Supreme Court. So SEBI, SAT, and Supreme Court. No civil court, no high court. Again, here it is 60 days. And allow after 60 days, but maximum 60 days. So there was 45 days, allowed after 45 days also. Maximum time period to dispose of is 6 months. Here, 60 days from the date of communication, and thereafter it can be extended, but to a maximum period of 60 days. Example. Stupid who is registered as an intermediary fails to enter into agreement with their client and hence penalized by SEBI. State to advise Mr. Stupid as what remedies are available to him against the order of SEBI. So first he can approach the SAT within the time frame which we have discussed just now. And even if SAT gives an order which is in line with the orders of the SEBI, thereafter he can approach Supreme Court. SEBI has imposed a penalty to Hotel Leela Ventures for violation of takeover code, that is substantial equation of takeover guidelines, and the directors are seeking your advice to apprise them within a time period for filing appeal with the SAT and Supreme Court. Suggest what will be the time period for filing appeal with SAT and Supreme Court. So in case of filing of appeal with SAT, 45 days from the date of order, and Supreme Court within 60 days of the communication of the order. B, in case of filing with SAT, 60 days. C, in case of filing with SAT, 30 days. D, in case of filing with SAT, 60 days. So which is absolutely wrong. So the correct answer is A. The SAT shall consist of presiding officers, judicial member, technical members, all of the above. Every bench constituted shall include at least one judicial and one technical member. Supreme Court is satisfied that the applicant was prevented by sufficient cause, then the application may be allowed to be filed with a period further extending not exceeding 60 days. Any person aggrieved by any decision or order of SAT may file an appeal to the Supreme Court within 60 days. Then now coming to miscellaneous provision from 16 to 26. Miscellaneous provision, power of central government to issue directions. So now without prejudice, the board shall exercise the power of the performances function in this act be bound by such direction on question of policy as the central government may give in writing. So the central government may issue directions to the board and the board will have to abide by those directions. Basically, the direction may be given as a matter of policy. And one which does not relate to policy, that may not be final. Obviously, at any point of time, the power of the central government will always supersede the board. So this is, these are all miscellaneous provision to give more power to the central government in case required. Is there fine general provisions? Yes. Special code. Yes. This is important again. As we have seen in company law, there is a provision of special code. Also here in SEBI, we have a provision for special code. Now, what does this code will do? This is being constituted for providing speedy trial of offences. And it will consist of only a single judge. This is an exam question, friends, MCQ, or a theoretical question, the constitution, they need a special code. So, appointed by the central government with the concurrence of Chief Justice of High Court, within whose jurisdiction the judge to be appointed is working. Obviously, the person shall not be qualified appointment as a judge of special court unless immediately before such appointment, holding the office of a session judge or an additional session judge as the case may be. For the special court, the Code of Criminal Procedure will apply to the proceedings. Offences by companies. This is the concluding part. Offences by companies. So where an offence under this act has been committed by a company, every person who at the time of offence was committed was in charge and was responsible to the company for the conduct of the business, as well as the company shall be deemed to be guilty of offence and shall be liable to be proceeded against and punished accordingly. So every person who was in charge at the time the company was punished or the conduct of business of the company, then the person in charge shall be, the person who was responsible shall be deemed to be guilty of the offence. Exemption is given that if he proves that the offense was committed without his knowledge, or probably has exercised all his due diligence to prevent the commission of such offense. And where it is proved that the offense was committed with the consent or connivance of, or is attributable to any neglect on the part of any director, manager, secretary, then such director, manager, secretary shall also be deemed to be guilty of offense. So here the provision has been incorporated to bring in those people who at the time of offense were committed, was in charge of this company. So to bring them under this net, this provision has been built in, and along with the people, the person, if any other KMP is also involved, and the whole act was committed with consent or along with all these people, they will be liable for punishment. So the question comes in, friends, fine, you are liable to punishment and everything, you are punished, heavy penalties being imposed. How the amount will be recovered? What is the provision for recovery of that amount? So if a person fails to pay the penalty imposed by the adjudicating officer, or fails to comply with any direction of the board for refund of monies. So one is the penalty, which we have seen under section 15A to 15HI, or where the refund of money under, let's say, CIS has been given, but they fail to comply with the refund. Fail to comply with the direction of any disgorgement order, any fees which is due to the board, then that will be a trigger point for the recovery officer to recover from such person on the amount specified in the certificate. That is known as the recovery certificate, RC or RRC, revenue recovery certificate, which shall be issued under these circumstances, and the recovery officer will now come into picture, and he will follow a certain process for attachment. The first attachment which he will do is the attachment and sale of person's movable property. Any shares are held by that person, he will sell those shares. Then attachment of person's bank account. Then attachment and sale of person's immovable property. Arrest of the person and his detention in prison. Appointing a receiver for the management of person's movable and immovable properties. So either they will do it on their own, or they can appoint a third person for the management of the person's movable and immovable properties. So if you believe that nothing can happen even if I don't pay the amount, our total assets can go in the hands of the recovery officer, and then he will take appropriate steps for the recovery. For the purpose of this particular section, this is an exam question. Kindly note it because few questions have been asked from this particular part, where it mentions that the person's movable and immovable property or money is held in the bank account shall include any property or money is held in bank account which has been transferred directly or indirectly on or after the date when the amount specified in it had become due. So if any transaction is done with respect to those properties after the recovery certificate was issued, and it mentioned that the amount has to be paid in 30 days, and if after 30 days any transaction takes place by the person to its spouse or minor child or son's wife or son's minor child, otherwise than for adequate consideration, and which is held by or stands in the name of any of the person aforesaid, and so far as the movable or immovable property or money is held in bank account, so transferred to his minor child or son's minor child is concerned, it shall Even after date of attainment of majority by such minor child or such minor child, we continue to be included in the person's movable or immovable property or money is held in the bank account for recovering any amount. So if you have transferred that amount to a person who was a minor and thereafter he attains majority, so even after attaining majority, the whole amount will always remain with the original person if the recovery is not made in full. Even under the case of any debts, then the legal representative will be liable, but his liability will only be only when penalty imposed before the debt and only to the extent the value of property transferred to him, not beyond that. So Harish failed to pay the penalty imposed by AO for an offense committed under SEBI. After the penalty was imposed, Harish transferred his residential property to his sister and fixed deposit in the bank to his minor son. Minor son has become major and deposits continue to be held by son. Discuss whether residential property can be attached by recovery officer. Now, obviously, the date has not been mentioned. We assume that it was transferred only as subsequent to the order which was released. Now, if you see the transaction, it is said the transaction is transferred to his spouse, minor child, or son's wife, or son's minor child. Only to that extent. So, if he transfers that property to his sister, probably that property will not be attached. But for the fixed deposit which has been transferred in the name of the minor, that will continue to be with the main person, that is Harish, and therefore can be attached. Ishan, a member of Dream Limited, obtained an order from SEBI against the company, but the company fails to redress the grievance of Mr. Ishan within time fixed. Consequently, SEBI imposed penalty on the company. The company, however, did not pay the penalty. Also, it state how the penalty can be recovered from the company. So, obviously, because the penalty was not paid, so therefore, recovery officer can be appointed. And if the person who is responsible, so at the time of offense, if the company is not paying the amount, all the person who are responsible for managing the affairs of the business, they will be liable to pay the amount. And if it is proved that the manager, the person involved, was supported by different people, they will also be liable to pay the amount. And if they fail to pay these amounts, the recovery certificate will be issued, and this will be the sequence of attachment. This will be the sequence of attachment. So friends, overall what we have seen today is a different angle with respect to certain areas of SEBI. To give just a brief, again, in short, the coverage, what we have done today is Constitution, which is very simple, which you can read, study. Constitution of Board and SAT. Board and SAT. Then the major things which comes is powers of board from section 11, and under section 11 the power to inspect books of accounts, power to give orders, power to give directions. Remember, inspect, power to give orders, power to give directions, that is all under section 11. So that section 11 is one of the prime section, which is again a bit confusing, as I said. Then 11C, 11D. C is again investigation. There's a whole lot of section of C, multiple subsections of C. So don't forget to learn section C under SEBI. 11D is cease and desist. Cease and desist. So Constitution, powers of board under 11. Remember, there are a few sections which are important. Inspect, power to give orders, and power for inquiry, investigation 11C, 11D cease and desist. Thereafter, we have 12A and CIS schemes, 12A and CIS schemes. That is important. Definition of CIS. What is not included in CIS? Definition of CIS and what is not included in CIS. 13, 14, you can skip if time does not permit. From 15A to 15I, the penal provisions, which we have discussed 15A, B, C, D, then 15E. If you want to segment it, 15A to 15D, then 15E, EA, EB, and then F, G, H, F, G, H, and I. So these are different sections which will call for different amount of penalty. F, G, H, and I. And again in the F, G, H, and I, there are different conditions of default. So maximum questions coming out from penal provisions, 11C provision, 11D provision. Thereafter, the powers of adjudicating officer and the conditions to adjudicate or factors which shall be considered for adjudicating the claim. Factors which should be considered for adjudicating the claim. That is important with respect to section 16 onwards. The power of the adjudicating authority and factors which we will consider. Thereafter, we have small miscellaneous provisions which can be ignored to the extent when it comes to SAT and Supreme Court and Special Court. So we have 3S, SAT, Supreme Court and Special Court. Timelines for filing appeal. The purpose for which special court has been designed. Speedy trial within 6 months. So for special court, just remember the provisions. And thereafter, at last, we have understood the recovery provisions and the offenses by companies. So if you see this overall picture, you will find that yes, SEBI is doable. It can be, we can study and we can crack all the questions of SEBI related concerns. And I would suggest review the penalty provisions, prepare that or look at the chart which is given in the notes, the penal provision charts. Probably it will help you in grasping it very fast. So any questions on this topic of SEBI, any doubt which you have? If you are there out there, Janvi, Mansha, Viraj, Pranav, if you want to raise any questions, any doubts, though it's an easy topic, not at all a complicated one. I would suggest that for SEBI orders, for practical case studies, you can refer few of the orders, go to the SEBI website, refer to the few of the orders, you will understand the nature of order which is given, which is general by and large. maximum cases it is on the same pattern. So no further questions. Great. So I hope the topic was clear, concise. So we'll conclude our session, and I'll be back again with the next session in next month on a very important concept of IBC. Thank you.